The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone. The next case is Window World of Baton Rouge, LLC et al. Versus Window World, Inc. et al. And we'll hear from the appellant.
Good morning, Mr. Chief Justice, and may it please the court. Matt Learberg for the appellant's Window World. I'd like to reserve 5 minutes for rebuttal, please. In this complex business litigation, a minority of Window World's dealers seek millions of dollars in damages and control of Window World's assets and intellectual property. Now, these plaintiffs are sophisticated investors with years or even decades of experience as Window World dealers. Yet their claims turn on the question of whether Window World tricked them into becoming or remaining highly successful Window World dealers by failing to turn over information that a franchisor might divulge to a franchisee. And to prove their claims, the plaintiffs want access to Window World's attorney-client communications, including a large number of draft version legal documents that were prepared by counsel, and a large number of email communications between Window World and its in-house counsel that forwarded information about legal questions that the company was facing. In the course of this litigation, Window World's attorneys reviewed about 239,000 documents for production and made claims of privilege over a small fraction of them, including some of these drafts and forwards. But the business court found, as a matter of law, that neither drafts nor forwards in this context enjoyed privilege here in North Carolina, and in the course of doing so announced rules of law on those two issues that are known nowhere else in North Carolina. The trial court made a number of other legal errors along the way, including 3 others on appeal here. First, the court's rewriting of the consent order on inadvertent disclosure that the parties had already agreed to at the outset of the litigation. Second, the court's misunderstanding of the law of discovery sanctions. And third, the court's refusal to allow Window World discovery into a partially dispositive defense, which is whether these sophisticated plaintiff dealers had need for a franchise disclosure in the first place. Now, Window World filed this appeal seeking clarity on these legal issues of first impression in this court, asking for the decisions below to be reversed and the case to be remanded for the trial court to apply the law that this court announces for the first time on remand. And this court's rulings in this case will undoubtedly reach far beyond just the parties to this case. The law of privilege is notably unsettled in North Carolina, especially in the digital age. The drafts, forwards, and large franchisee exemption issues are issues of first impression in this court. And this case provides an opportunity for certainty, not just for Window World, but for all of the in-house lawyers throughout the sophisticated business community in our state to know exactly what is protected and what is required of them legally and what is not.
For clarity of context, is this a discovery sanction case?
Justice Morgan, I think parts of the order on appeal do relate to sanctions, but the legal issues in the case, some of them do arise in the context of sanctions, but for drafts and forwards, for example, those are legal issues that arose as a predicate to sanctions. And in fact, that structure is really important here because where the trial court went astray was actually starting out with these incorrect legal conclusions by coming to the wrong answer on the law of drafts, by coming to the wrong answer on the law of forwards, when those are about half of the documents in question. The trial court got off on the wrong track and ended up kind of compounding those concerns into a sanctions order that the court issued, again, without authority under our rules, but that's why those legal issues really are the fundamental question. That's why we haven't come to this court asking this court to review hundreds of individual documents. Instead, we're asking this court to look at the pure issues of law, these issues of first impression, to announce what the law is in our state, and to allow the perfectly able and capable business court to spend the time to apply those issues of law and rulings to each individual document in the case.
Yeah. I want to be able to appreciate the context that you're presenting, since you say some of this may be very impressionable in terms of other areas of the law. I thought that this was set up in the context of something much more narrow and case specific, which would be whether or not discovery sanctions were appropriate in terms of these clawback provisions that appear that were determined in the court. But actually, you're looking at this as being more far-ranging in terms of talking about attorney-client privilege as to work product.
That's absolutely right, Justice Morgan. The sanctions issue kind of analytically is several steps down the road past many legal errors that the trial court made. In a sense, it's the last question, which is if the trial court appropriately applied the law on all of these predicate issues and the trial court properly interpreted Rule 37, then what would the appropriate sanction be for discovery? It's the last question in the case, not the first. And to kind of turn to those questions of drafts and forwards where the law is so unsettled, at least in this state, the business court veered off track and adopted two rules for these two that are not the majority rules across the country. First, starting with the questions of drafts. There are actually three different rules throughout the country on the question of whether when an attorney prepares a draft or maybe an early version of a document that might later be disclosed, for example, an SEC filing or a franchise disclosure document, are those drafts protected or not? The trial court understood there to be two rulings there, two possible paths, but there are actually three. The first is the most severe. It's what the plaintiffs advanced below but have not advanced on appeal. And that's the idea that any draft of a document that eventually will be finalized and disclosed, all of those drafts are just discoverable and you have to turn them over. That's not the law in many places. There is a Fourth Circuit case from about 30 years ago that holds, it's an under seal case, and that's the law in that Fourth Circuit case. There's the majority rule, which is that drafts are simply protected. If an attorney is sitting there preparing a draft of a document for the client, and those drafts are going back and forth between the client and the counsel, whether that counsel is outside counsel or in-house counsel, those drafts are protected. They're not discoverable, just like drafts of expert reports aren't discoverable, or drafts of judicial opinions, or drafts of appellate briefs. Drafts or early versions are simply not discoverable. That's the majority rule, and that's the rule that Window World has advanced. The trial court following
Mr. Learberg, the trial court claims it paragraph 107 that it is in fact adopting the majority rule. I take it your contention is that Judge Bledsoe was mistaken in his count.
And in fairness to Judge Bledsoe, there is some of the case law out there does kind of blend the middle option, which the business court adopted, and the position forwarded by Window World, which is just that drafts are locked up, period. Under the Shennett case and the kind of line of cases that followed it, there are some courts that have chosen a middle ground, Justice Ervin, and their middle ground is that for every draft, any of the words or language that made it into the final draft are discoverable, but any portions that were revised during the drafting process are not. The practical impact of that is that in a version, say a document goes through 10, 11, 12 versions, then counsel's supposed to go through all of those versions with the black marker or the modern equivalent thereof and scratch out all of the language that was ultimately cut. That would be painstaking and require a lot of time. And more importantly, the only thing it could possibly reveal is exactly what the client and the attorney were discussing in the course of reviewing the document. On this, suppose there's a section that requires a particular kind of confidentiality, and in one of the versions, half of it is stricken. The inference is that the client and the attorney were worried about something in the confidentiality context. The only value to the business court's rule is that it provides an adversarial window into the attorney's thought processes. But that's exactly what the attorney-client privilege is intended to protect. So the unfortunate...
So let me follow up with Justice Ervin's question. In paragraph 105, the business court cites to the Fourth Circuit. In paragraph 106, it talks about the majority rule that protects any information that is not ultimately disclosed to a third party or ultimately in the final product. 107, the court says it adopts the approach taken by a majority of federal courts. So what's wrong with that?
Chief Justice Newby, the business court is wrong to say that its rule is the majority rule. There's a difference between the second and third approaches.
Is it your contention that the majority rule is that no draft under any circumstances is outside the scope of the attorney-client privilege?
Yes, Justice Ervin, but I do want to clarify, all of these three approaches are in the context of documents that are drafts of final documents where the final document will be disclosed. So
your argument is it your argument that the majority rule across the country is that as long as the final document is disclosed, no draft whatsoever under any circumstances is subject to discovery because of the attorney-client privilege?
yes, provided that the drafts are in the context of the attorney-client communications. I mean, certainly if a client drafts a document and then just releases it, that's not a communication. This is all in the context of the kind of back and forth drafting that happens between an attorney and counsel. And when that document is finally disclosed, those drafts are protected. And again, it's because the adversary in a litigation has 100% of the information that they could discover under Judge Bledsoe's rule, except they don't have the opportunity to try and reverse engineer attorney mental impressions and thoughts in the discussions between an attorney and client. So Chief Justice Newby, to circle back to your question, the trial court understood itself to be kind of adopting the more protective rule, but in fact adopted the middle ground rule. And I think that's the source of the confusion that appears both in the trial court's opinion and in the briefs on this issue. And lest there be any kind of confusion over exactly what the trial court required, not only did the trial court issue its ruling.
Yeah, let me jump back in. So paragraph 107, do you disagree with the trial court when it says under either approach, however, documents that are adopted as written and published to third parties are no longer protected from disclosure under attorney-client privilege?
Chief Justice Newby, if there is a final draft, the version 11 that's then made into a PDF, then there's really no difference between producing the PDF and the final draft. That final draft that's never edited, by all means, is discoverable because it's identical to the final draft. The key practical problem with Judge Bledsoe's ruling, and he announces this in paragraphs 111 and 113, and this is record 7734. The court said that the court will allow Window World the opportunity to redact the portions that were not ultimately disclosed, if any. There's a disagreement in the briefs in this case as to whether that was required, but I want to point the court directly to the record where Judge Bledsoe does require that. And remember, it's not just these couple hundred challenged clawback documents. It's not just the 150 sample documents that the special master looked at. There's this other batch of privileged documents, documents over which Window World claims privilege. That's about 1,300 documents. And it looks like about half of those are drafts or forwards subject to whatever rulings this court issues. Those documents, under Judge Bledsoe's rule, Window World would need to go through every one of those in every version and every draft and try and redact out, if it's even possible, exactly which words didn't make it into the final. There's just no benefit to litigation to having that be the rule. And the fear here is that, I mean, one of the benefits of having our kind of famous and renowned business court, one of the benefits is that it provides clarity in the law, and there's a direct appeal to this court to declare what the law is for the businesses in North Carolina. But there's a practical drawback from the field, and that is that companies and lawyers follow the business court decisions as though they were precedential. I mean, and it's only prudent that if the business court is the only court in North Carolina to set forth a rule on a particular area of law, the business community cautiously follows it. So, that's why we brought these legal issues before the court, because without an appeal, it affects not only Window World, but businesses across the state will be following Judge Bledsoe's ruling on these pure issues of law. The forwards issue is somewhat related to the drafts issue in the sense that these are both kind of new issues that look different from traditional attorney-client privilege questions, but only because of the digital age and because of the use of email to communicate with counsel. But just like in the drafts context, the rule really shouldn't change just because we're talking about electronic documents or electronic communications. So in this case, I think a helpful kind of framing for it is to think about what would happen in the 80s or 90s in the practice of law. What would happen is that a client would have a legal problem. The client might walk down the hall or pick up the phone and call his or her lawyer and say, here are the underlying facts. I have these 10 things I just learned. What should I do? And the law is completely settled that the contents of that phone call are protected. Now, those 10 underlying facts aren't protected. I mean, facts are always discoverable.
Well, since we're now talking about a form of law practice that I have some knowledge of, let's say somebody walked into my office when I was in private practice and handed me a set of documents and walked out. We never said anything. In the 80s and 90s, when I was practicing, would those documents have been privileged?
Well, Justice Ervin, if the documents are coupons for lunch or something that has nothing to do with the practice of law, then no. But if those documents are underlying facts that are then discussed or are intended to be discussed with the attorney, then absolutely yes.
My hypothetical didn't include any discussions. Let's say a client, one of my business clients, walked in, gave me 5 documents, handed me those documents, and I never heard anything further about it.
In Justice Ervin, there are certainly...
Would they have been privileged?
Justice Ervin, there's one of the underlying questions, and this court hasn't kind of gone down the Upjohn path from our United States Supreme Court, but there are certainly questions in the business context where you have an in-house lawyer as to exactly which communications with your in-house counsel are intended for legal advice versus business advice. So by all means, that would be a threshold inquiry. Were those documents handed to you for the purpose of legal advice or not?
I hope they weren't asking me for business advice, but some of these documents, the documents that are at issue here, as I understand it, were sent to the in-house. Right?
That's right, Your Honor. And that is the forwards issue. These are underlying facts. For example, an email containing a concern from one of the dealers, or raising issues that start to touch upon compliance issues. That underlying email that might be from a third party to a business person at Window World, everybody agrees that's discoverable. Those are discoverable and they were properly produced in this case. The question is, what happens when a business person at Window World takes that email, forwards it without commentary, which is what I always advise my clients, don't put commentary in emails, forwards it to the lawyer and then picks up the phone and calls. Is that email forwarding it part of the attorney-client communication? And the majority rule across the country is yes, because there's no reason for clients to send facts to lawyers unless they intend to get legal advice about those facts.
To ask you the same question I asked you with respect to draft documents, if you look at paragraph 100 of Judge Bledsoe's order, it says, quote, accordingly, the court concludes that it's taken by the majority of courts as sound. So again, it me as if Judge Bledsoe believes that his order is consistent with the majority rule around the country. Again, are you disagreeing with his case count as to what's the majority rule and what isn't?
Yes, Justice Ervin.
Okay.
That's just
fair answer. I'm just trying to, it's always helpful to understand what somebody's trying to help you, and that helps. Thank you.
And in Judge Bledsoe's defense, many moving parts in this case, many moving parts underlying these orders. And that's why we haven't sought to identify every decision the court made that's under an abuse of discretion standard applying, that are within the court's discretion to decide how to handle his courtroom. We've only sought out these legal issues so that this court can pronounce what the law is on these issues that affect everybody beyond this case.
To be fair to the trial court, paragraph 112 indicates that was a draft letter to a non-plaintiff store owner, no legal advice, not drafted or drafted by a non-lawyer, and Window World offers no evidence to suggest it was not adopted as written. There are multiple documents identified by the trial court as not fitting the category that you're arguing to us right now. Wouldn't that be correct?
Well, I don't think so, Chief Justice Newby. The problem is that the court in paragraphs 109 through 113 is applying its understanding of the law to particular documents. But if this court were to reverse and change what the law is and declare that the law is different, then these findings or these conclusions here don't hold water. We had come before the court and said, drafts are not discoverable, period. And the privilege logs, they show, because they always do in every case, what the lawyer's due diligence revealed about whether it was a privileged communication. And I think this is a critical point. For forwards, for drafts, for any email, any communication, any document that appears on a privilege log in business litigation or otherwise, the reason it's on a privilege log at all is because a lawyer for a client had to go through and assure him or herself that there was a colorable claim to privilege over that document. That's how it gets on the privilege log in the first place. So for Judge Bledsoe to say that Window World had not attempted to show that any of these documents were privileged is just not true. That's what the privilege logs show. They show the result.
Is it your contention then that the mere placement of a document on a privilege log standing alone is a sufficient showing that the document was forwarded for the purpose of obtaining legal advice? Sorry, I botched the question probably, but is it mere placement of the document by itself on a privilege log sufficient in your view to establish that the document that was forwarded to the lawyer was forwarded for purposes of legal advice?
Yes, that is sufficient to establish at least a prima facie case. Now,
and
of course, it has to comply with 26.
Your dispute with Judge Bledsoe then is that Judge Bledsoe required an additional showing before the privilege was recognized?
Not quite, Justice Ervin. In our privilege,
where am I wrong then?
Because in our privilege logs, we identified draft or forward documents and said, these are privileged because they were drafts, or these are privileged because they were forwards. That's enough to create that presumption, because we're all officers of the court, that says, yes, this document's privileged. And in 99.9% of business litigation, that's enough. Now, of course, there's always a right to challenge a privilege log and for opposing counsel to probe it. This is set forth in Rule 26 to make sure there's enough information in there for opposing counsel to decide, is this really a privileged communication? So for example, a communication to in-house counsel that looks like it might be for business reasons, well, that might be something that opposing counsel can challenge. So there is the possibility of this, a dispute over evidence. But again, part of the value of the rule that we're saying in drafts and forwards in particular is that that cuts short a lot of the back and forth discussion as to whether it's privileged. If facts and information are sent to counsel and the outside lawyers during litigation find a reason to believe that it was for legal advice, that should be enough. It should be enough. There shouldn't be this kind of side litigation about the litigation that gets the whole matter off track. And that's kind of part of what happened here. And by all means, part of the reason it got off track was because of mistakes that Window World made in the discovery process. We are not hiding from that. We understand that those mistakes were made, and the trial court has the ability under Rule 37A to impose attorney's fees that are commensurate, not to punish, but to try and level the playing field for those mistakes. And that's something we know we're going to face on remand, no matter what this court rules, is those fees as sanctions under 37A. That's coming. The problem is, because of the position of the business court, and certainly the position of this court, it shouldn't be a case where the bad facts and the kind of underlying way these legal issues came about contributes to the making of bad law that businesses across the state have to follow. And that's why we're here asking for clarity on these issues. There is the issue on appeal of the large franchisee exemption, and it ties directly into these questions. And again, that's because the plaintiffs are trying to prove this kind of fraud or misrepresentation case that is all around what kind of disclosures Window World should have given to them in the context of them becoming licensees or franchisees. And I know that this, this court has the jurisdiction without a doubt under the Constitution to consider the large franchisee exemption rule. This court looks at cases, not issues, under the Constitution. I also admit that this court has the discretion not to look at that issue. But we asked this court to go ahead and examine the large franchisee exemption question for several reasons. First, this is the kind of case, and it doesn't come up that often, but RPR and Associates from the Court of Appeals is an example where it does, where handling the issue now is actually more efficient than delaying it to a later date. And that's because it's potentially dispositive of several of the claims of the plaintiffs. And the issue is also already fully briefed and before this court, and it ties into the other issues that the court is considering. So we asked this court to go ahead and look at the issue that lies at the heart of this case, which is that these plaintiffs are sophisticated investors, and regardless of how they set up their franchise entities, whether as individual owners of the franchise, single purpose LLCs, that the federal law on this is fairly clear. And until Judge Bledsoe issued his ruling on this, no one has ever contended that it means what Judge Bledsoe thinks it means. So again, hitting the same theme, this is a real concern for the franchisors and franchisees in North Carolina who are going to look for what the guidance is in this state and what the law is in this state on that issue. They're going to look to Judge Bledsoe's opinion, which is incorrect. So we asked this court to take that issue up as well, for all of the reasons set forth in our brief and the briefs of the amicus parties. I see that I'm running out of time, so I'd like to reserve the balance of my time for rebuttal.
Thank you, counsel. We'll hear from the appellate.
Thank you, Mr. Chief Justice and Associate Justices of the Supreme Court. My name is Charles Coble, and I represent the appellees on this appeal who are the plaintiffs below. I want to jump right in to the last question you asked, Justice Irvin, and the answer that you received, because I believe that that exchange highlights just how far afield Window World's arguments have gotten from the law of this court, and just how erroneous the positions that have been taken here are. This court in Miller held, and I'm quoting, "The burden is always on the party asserting the privilege to demonstrate each of its essential elements." And as we know, Miller has a 5-part test. This burden, the court continued, may not be met by mere conclusory or ipsy-dixit assertions. So of course it's the law, Your Honor, that a party asserting privilege doesn't discharge that burden by simply writing on a privilege log, email between so-and-so and so-and-so, P for privileged. It doesn't approach the sort of showing that's required. And here, at its very core, the reason that the business court ruled in the way it did on the drafts and the emails that Window World challenges is because it found it did not carry its burden. It considered the facts that were before it, and it found that Window World had not carried its burden under Miller to demonstrate that the elements of privilege were met. And that's really the fundamental complaint that Window World has here. But rather than do as it should, which is argue to this court that it believes the business court abused its discretion in applying Miller to the emails that were before it, it asked this court essentially to overrule Miller and to relieve it of that burden, such that the sort of presumptively, as it says in its brief, presumptively emails may be treated as privileged as long as they are sent to counsel. So I think that that's a striking point.
Hypothetically, I had a discussion with Mr. Learberg about version of this subject. We have an email that contains information that's forwarded to the in-house counsel without comment. What additional showing do you contend that Judge Bledsoe's orders require before a valid claim of privilege can be made?
Well, Your Honor, I would actually go to Miller, which the fourth element of Miller requires that a communication, in order to be privileged, must be made in the course of giving or seeking legal advice. And as we saw from Judge Bledsoe's order, he reviewed the facts that Winterworld presented here and assessed whether those facts established that either the email in question contained a privileged communication, or it contained a request for legal advice, express or implied, or it communicated some form of legal advice. And he found that Winterworld had not met its burden on the emails that it found non-privileged. If you look through appendices A and B to the privilege order, which run over 23 pages looking document by document by document, you'll see that there's some exchanges where the court found there was a request for legal advice, and it found that those exchanges were privileged. For the ones that it found non-privileged, it found otherwise.
My understanding of Mr. Learberg's response to my similar question, and he's got a little bit of rebuttal time, and if I'm wrong, I hope he'll correct any misunderstanding I may have. It seemed to me that he was saying, in effect, given the duties of attorneys as officers of the court, the mere placement of a particular document on privilege law standing alone ought to be enough to be a sufficient invocation of the attorney-client privilege. Assuming that that's his argument, what's your response to that?
Again, Your Honor, that doesn't comply with, if you look at privilege logs, they're by definition conclusory. They simply describe a communication and indicate that it's privileged. They don't provide any facts that substantiate that there was, Mr. Learberg said a number of times, well, that there's something's forwarded and then there's a conversation about it, or something was discussed and then factual information was provided, or that the facts were attendant to some larger discussion that was protected by privilege. Well, it's incumbent on Winterworld under Miller to bring forward those facts to the court with respect to any document that it claims is privileged. And as the proponent of the privilege, it bears that burden to bring those facts forward and show that the general counsel had a discussion with the president of the company. And in conjunction with that, the president of the company forwarded some information that related to that discussion. They could present those facts. They just didn't do that here, as the court found. The record shows that the business court here bent over backwards to give Winterworld opportunity after opportunity after opportunity to present facts to substantiate its claims. That included the briefing on the motions, that included the hearing, that included the submissions to the special master. After that occurred, the business court invited Winterworld to present ex parte materials, and it did indeed submit 5 ex parte affidavits and 2 ex parte briefs. Winterworld then asked to also be able to submit exceptions briefing, which the court allowed. So there was some 6 opportunities here to present facts for these emails to show that they were either express or implied requests for legal advice, or that they were related to a request for advice, and Winterworld simply didn't carry its burden. That's its basic complaint here, is that the business court found it did not carry its burden, and that determination is a is a abuse of discretion reviewed matter. I think that's the other core place here where Winterworld's argument has gotten way, way, way off course and contrary to the authority of this court as to what standard to apply. You heard Mr. Learberg say that the business court announced law of drafts, or that it announced law of forwards, or that it announced a rule of law here. It did no such thing, Your Honors. It simply took the existing law under Miller and McIntosh and their progeny and applied that law of privilege to a new set of documents. It is not the business of this court every time a new category or a different category of documents comes before a trial court to give de novo review to that set of materials simply because it hasn't been addressed before. And the appellate courts have said that. In Sessions versus Sloan, and I want to quote, if you'll bear with me a bit at length from this case, there was an issue of first impression relating to privilege. The court there said, now I'm quoting, after reviewing the relevant case law, we believe the question of whether subject lines of emails must be protected from discovery under attorney-client privilege is a question of first impression in North Carolina. However, just because the form of the document or communication is new or different does not mean that we look outside our jurisdiction for authority. We hold the same 5-part test applies for the subject line of an email as it does for any communication allegedly protected under attorney-client privilege. Defendants bear the burden of establishing each essential element of the privilege pursuant to the five-part test recognized by our Supreme Court. And the Court of Appeals then went on and affirmed the trial court's application of existing law to email subject lines, and affirmed it because it found no abuse of discretion. It didn't do, as Windoworld invites the court here, to make some general pronouncement of how Miller and its progeny ought to be applied to a new category of documents and then send the case back. That's not this court's function. This court doesn't announce the law in advance. It doesn't write a treatise on privilege and up in the air and send it back for to chart the course for the trial courts going forward. It corrects error. This court sits to correct error, and this appeal was Windoworld's opportunity to argue and demonstrate that there was some error in the application of privilege that the business court made here, and it doesn't do so, and it can't do so because there was no abuse of discretion. I want to circle back to where you started, Justice Morgan, that the context here. Windoworld has appealed from a 114-page interlocutory discovery order that did two things. It found, in its words, that Windoworld engaged in numerous discovery abuses by cavalierly and recklessly invoking privilege, and it sanctioned Windoworld for those abuses. The decision is thorough and meticulous, in just as much as was the 16-month process by which the court reached it. As I said, it gave the Windoworld here, the proponent of privilege, every opportunity to substantiate its privilege claims and every opportunity to defend its conduct, but ultimately found that it had failed to carry its burden, failed to carry the burden that it bore as the party asserting privilege. So this was not a rash ruling. This was not a haphazard ruling. This was a measured, careful, thorough decision that was rendered in the considered judgment of the business court only after giving Windoworld every opportunity to back up claims of privilege that it ultimately was unable to do. In Raymond versus NC Police Benevolent Association, this court held that the trial court is best suited to determine through a fact-sensitive inquiry whether the attorney-client privilege applies to a specific communication. And this court, not 9 months ago, in Global Textile Alliance versus TDI Worldwide, once again reaffirmed that abuse of discretion review applies to privilege determinations. Now, Windoworld, in its brief to this court, just flat out misstated the standard applied. It basically said the very opposite. It said that the ruling, the trial court's application of the law of privilege is reviewed de novo. That's the quote from its brief at page 30. That's just directly contrary to this court's holding in Global Textile, which was that it reviews trial court applications of privilege for abuse of discretion. And recall that Global Textile itself involves some novel questions of the involvement of an agent in communications that were alleged to be privileged. It involved novel questions about whether a functional equivalent test ought to be applied, whether an exception to privilege ought to be recognized under the Covell case. And this court applied abuse of discretion review up and down and across the board to those matters, just as it should have, and just as is consistent with a long line of authority. And that's really fundamentally where Windoworld declines to engage. You know, it doesn't anywhere in its briefing argue that the business court abused its discretion, because there would be no basis for that argument. The opinion here, the 114-page order, stands as a very testament to a reasoned decision-making on the part of a trial court on a question that really turns on, as the court in Raymond, this court said in Raymond, on the considered judgment of the trial court as a court that's closest to the facts. You know, recall here that we have a business court that has held this case since January of 2015 and knows the full context and scope and scale of the parties' claims and the sort of the context in which this behavior on the part of Windoworld took place. And it was very clear in its determinations that not only were the privilege invocations groundless, but the conduct itself represented a grave set of discovery abuses, and it cataloged those in a long laundry list of findings that Winterworld does not challenge.
Can I ask you a question about your response to what I understand Winterworld's argument to be about the, and I'm looking in particular at paragraph 113 of the court's order, but as I understand it, Winterworld is saying that having to redact the portions of the drafts is actually a different standard than saying drafts themselves aren't discoverable, and they are arguing that that's just unworkable, unduly burdensome, and so what is your response to that argument?
Thank you, Justice Earls. I'm going to answer that in a couple of ways, and one by referring back to some of the questions that were made to Mr. Learberg before. First of all, there are two rules. There are not three. The two rules that the business court considered: the minority rule from the Fourth Circuit case that affords very little privilege protection to drafts. It held that where there was at any point there becomes an intent to share a document down the road, then privilege is lost, and not only in the drafts in their entirety, but also in the communications about them. The majority rule, and Justice Newby and Justice Irvin, the business court was right on the mark in describing the rule from Shennett as the majority rule. It is indeed the majority rule. Hold that in a way more protective of privilege, that a preliminary draft may be privileged. And that's where Winterworld pauses. They don't want to go to the disjunctive part of that, which is may be privileged unless the draft, and to the extent to the draft, is later shared with third parties. If a draft is shared later, then that portion of the draft loses its protection.
If I understand Mr. Learberg's three-part categorization of the cases, his preference would be for us to hold that all drafts were fully protected. Are there any cases that hold that, to your knowledge?
No, there are none. There's a treatise, and this treatise that you see repeatedly cited within the Winterworld's briefing, I think, is the only source of that position. There's not a third position, and we've laid this out carefully in our brief, that most of the cases, in fact, that Winterworld cites for the supposed third rule, in fact, are cases under the majority Shennett rule that observe, as Shennett notes, that drafts may be privileged, but not to the extent they're later shared with third parties. The case that Winterworld perhaps relies on the most, the case of the In-Ray New York Renew versus Moisture Lock product liability case out of New York, that was the source of the statement that Mr. Learberg made, and this gets, I hope, to more closely to your question, Justice Earls, that there's some sort of, undue burden associated with redacting those portions of a draft that were not shared, and that the line about the line-by-line redaction quote appears in that In-Ray New York Renew case, but it's as if the rest of that paragraph were just disregarded because the court continued. Yet, despite its costs, the Shennett-Schlegel view is the one most consistent with the policy of privilege. It allows and encourages the client to seek legal advice on the propriety of language in a draft without overprotecting the draft in such a way that its disclosure is based even as to portions that are clearly intended for public disclosure. As the Shennett-Schlegel rule view is the most consistent with the policies of the privilege, I conclude that it's the most consistent with New York law. So even the case that Winterworld quotes in both its opening brief and reply brief for those supposed problems with the majority rule the business court adopted here, that very case adopted the very same rule, noting that while there are costs, it's still the best, there may be costs, that's still the most protective of privilege. And here, I think another point, Justice Irvin and Justice Earls, that needs to be emphasized, that there's no evidence in the record anywhere that any of the drafts would be subject to this sort of redacting that is sort of waved around as a parade of horribles. I think the most egregious example of the argument here that Winterworld has made is at page 7 of its reply, where it argued that the draft franchise disclosure documents at issue identified as sample documents 16 and 17 significantly differ from their final versions that were actually adopted and published to third parties. But look at record page 7761, Your Honors. The business court expressly found the very opposite. And I'm quoting from that record page. The business court found in its appendix, WinterWorld has offered no evidence to suggest that sample document 16 or sample document 17 was not adopted as written and published to third parties. So if you look up and down appendix A and B, you'll see that the business court separately considered the evidence WinterWorld offered as to each of those documents and made document-specific findings as to each draft. Going back to Justice Morgan, your question, this is a narrow case at its heart because it is a case about the particular documents over which WinterWorld claimed privilege here, and the fact that it was unable to carry its burden of showing that 164 of those documents, in fact, are not privileged. A staggering error rate, as the business court found here. So if WinterWorld contends that the finding I just read about sample 16 or sample 17 is wrong, this appeal was WinterWorld's opportunity to say so. This appeal was WinterWorld's opportunity to say, you know what, the business court's finding on sample 16 and 17 lacked competent evidence, and it should be overturned by this court. It doesn't make that argument. In fact, it hasn't made that argument as to any finding, not a single one in the entirety of the 114-page order. By the same token, if WinterWorld had facts that it believed supported the notion that sample 16 or sample 17 changed before being shared with third parties, it had multiple opportunity after opportunity to present those facts to the business court. Same as emails, as we talked earlier. If it had facts that showed that these emails were attendant to some legal discussion protected by privilege, it had the opportunity to present those facts to the trial court, and it either didn't present them or it presented them and the court wasn't persuaded by it because the court found otherwise. So Justice Earls, there's this notion that redaction sort of cast doubt on whether the approach that the majority of courts have followed here is to drafts is the right one, but the predicate is absent here, Your Honor. We don't have any document that the business court found actually would need to be redacted. Each and every draft that the court found non-privileged here was a document that the business court found, as I read with respect to sample 16 and 17, WinterWorld was unable to show was not adopted as written and published to third parties. So, each of these arguments, Your Honor, hits a dead end ultimately from WinterWorld's part, in that it cannot get past the abuse of discretion overlay that applies here, and it can't avoid it by trying to suggest there's now somehow going to be a law of privilege as to each and every category of document that may come before trial court.
It seems to me Mr. Learberg in his reply brief responded to this argument as made in your appellee's brief by saying, in effect, no, we didn't go through here document by document and try to argue about specific documents, that instead our assumption was that we had certain underlying legal principles that we think the trial court got wrong, and therefore what we're asking is for the court to clarify what the law is in these particular areas and then send this case back to the trial court, which is better suited to do the kind of document by document view that would ultimately have to be made. Assuming I've got his argument and we're close to correct, what's your response to that?
Well, I mean, I do believe, Justice Erwin, that's what they said in their reply brief, but it's wrong. It's incorrect. The business court here is not announcing some rule of law as to drafts or email forwards. What the court observed is that our appellate courts have not yet had occasion to review a case that involved email forwards or drafts. That doesn't mean that what would otherwise be abuse of discretion review converts into de novo review. The business court, as I said earlier, cited and referenced a number of cases that touch upon prong 4 of Miller, which is that the communication be made in the course of giving legal advice or requesting legal advice. that there, the Isom case from the Court of Appeals, the Brown case, Sessions, which I quoted from earlier, Evans, those all involved questions, some of them novel, about when was there truly a request for legal advice, or with respect to drafts. Of course, the principle is under prong 2 and prong 5 of Miller that a non-confidential communication is not privileged, or a communication that maybe was originally confidential but then shared, privilege is waived. So the problem with the argument, Justice Irvin, is that it would convert this court into a court to make pronouncements in advance on privilege law, rather than sit as it should as a court of correction to correct error when error is made below. There is no such thing as a law of drafts or law of force. Contrast that with Miller itself. In that case, the trial court held that in a criminal investigation, it would apply an interest of justice test to determine whether a confidential communication between an attorney and a deceased client ought to be revealed to the government. That was an announcement of a new legal standard, right? We don't have that here. We simply have the court in its determination concluding that these particular drafts and these particular emails do not satisfy prong 4 of Miller because the factual showing Winterworld made was deficient. This court, the privilege issues in this case have already consumed 3 years. I think Winterworld at its core here is sort of inviting nothing but further delay and wishing to avoid the consequence of arguing the standard that really applies, which is abuse of discretion. When that standard applies, clearly Winterworld loses. And in fact, they don't even try to argue otherwise. But for this court to just pronounce in the abstract what how Miller and his progeny ought to be applied to drafts, and then send the case back after Winterworld's already had 6 opportunities to submit its facts, and the court makes findings again, and then 2 years later we wind up back in this court again. I mean, where does it end? That's not the function of this court, and that's not the proper role of the court, and particularly in privilege determinations as we see here, which are matters on which the court defers most closely to the judgment and discretion of the trial court.
In addition to the discovery issue, the appellant has asked us to go ahead and review the large franchisee exemption ruling by the business court. What's your position on that?
Okay, thank you, Chief Justice Newby. I mean, there's several reasons that this court should not do so. First of all, that appeal should be dismissed for lack of jurisdiction. Winterworld here appealed from a privilege order that touched upon a substantial right, as it was entitled to do. The order which addressed a large franchisee exemption was issued 9 months earlier on an unrelated motion that had nothing to do with the privilege matters that are properly before this court. The suggestion from Winterworld that this court, simply because it has a substantial right appeal before it, ought to be able to consider each and every and any interlocutory order and decision that was made in this case is simply an invitation to chaos and havoc and inundation of this court with improper interlocutory appeals. I mean, I counted up, Chief Justice Newby, 21 different interlocutory decisions that Judge Bledsoe's made in this court other than this one. And so by Winterworld's argument, the parties could have just thrown all 21 of those arguments in simply because a privilege appeal was properly before you. You know, another problem with that, Chief Justice Newby, is that the reason we're here is that Winterworld engaged in a severe pattern of discovery misconduct as found by the business court in findings that Winterworld does not challenge. And I need to pause on that. The case authority from this court emphasizes that where a party below on appeal does not challenge factual findings, they are binding on this appeal. They are binding here, which really leaves only the question of how to, whether the court abused its discretion in the privilege rulings it made based on those findings, and the sanctions it issued based on those findings. So the
other argument that that Mr. Learberg made today, and also was made in the brief, is that this large franchisee exemption issue is of sufficient importance that it would expedite the final resolution of this case if we went ahead and decided it. What's your take on that argument?
Well, there's certainly no cases from this court that recognize such an argument. I would suppose any party that loses an interlocutory decision would come to this court saying, this is a really important issue, Your Honors. Please hear it now because it would be more efficient. I mean, this court considers matters that are interlocutory after judgment is entered. And at that point, we know for certain what issues were important and what issues were not. We don't know that to be the case now. If Winterworld thought this issue was so important, why did it not petition for certiorari 9 months earlier when the decision was reached? Another point, Your Honor, is that recognizing an appeal of an unrelated order like this in this context would allow a party to profit from its own unchallenged discovery misconduct to sort of leverage that into appealing from a otherwise unappealable order that it lost on earlier. And there's no equity or there's certainly no interest of justice in that. And then lastly, Your Honor, Chief Justice, the court below had multiple bases for denying the discovery that is at issue with regard to the large franchisee exemption. It denied that discovery on the basis of Winterworld exceeding its number of interrogatories and on the burden it would impose. Winterworld does not challenge either of those bases on appeal, which means that that portion of the order should be readily affirmed. So, Your Honors, unless there's further questions, I see I'm almost out of time. And so in closing, I would just say, this was no ordinary discovery order. It's for 114 pages, attest to the care and the thoroughness and the thoughtful consideration that the business court gave to these privilege issues and to the propriety of the sanctions it awarded. Under Global Textile, this court defers to that judgment. Winterworld has not demonstrated otherwise, and the appellees and plaintiffs below respectfully request that the court affirm the order in all respects.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. An error of law is always an abuse of discretion, and errors of law, issues of law are reviewed de novo. So that's why the de novo standard review is correct here. Mr. Coble said that the trial court did not announce any pronounce any rulings of law, but I commend the court to paragraphs 43, 100, and 107, where the court did just that. And on the large franchisee exemption, record page 3142. This is a court of review, not a court of first view. That's why we're presenting these legal issues for the court to declare what the law is and to allow the thoroughness that Mr. Coble and we agree that the business court used to apply that thoroughness again under the right rules of law. Mr. Coble says that we didn't challenge findings of fact. The district court's opinion on appeal has 31 findings of fact, none of which are the findings that the plaintiffs would have us supposedly have conceded. It's just the first 31 paragraphs in its order. And the rulings of law that the court made are legally erroneous. The rulings that we're asking this court to make are completely consistent with In re Miller. The Miller case, yes, it has elements to be applied, and the rules we're proposing fit best with those elements. An attorney sitting around drafting a document for its client to review, that's an attorney-client communication. It checks the boxes of In re Miller. A client forwarding information to counsel in advance of a discussion on those facts and seeking legal advice, that checks the boxes from In re Miller as well. So it's our position that's most consistent with this court's precedents, not the trial courts or the plaintiffs. On the questions of drafts, there are absolutely 3 different views on this. And I think the parties are talking past each other when discussing to the extent that those drafts are later shared. If a document has several attachments and some of those attachments are verbatim what's later shared, then of course, those can be produced. The question is whether that gets into a line-by-line edit, which is exactly what the trial court asked us to do in paragraphs 111, and 113. On the large franchisee exemption issue, there's no question that this court has jurisdiction. The Constitution and the statutes, 1-270, Article 4, Section 12, this court has jurisdiction. There's no jurisdictional barrier to the court reviewing the large franchisee exemption. Instead, the question is, while we are already here and the issues are already briefed, and the franchise community, both franchisors and franchisees across the state, are waiting to hear what this court says on it, or waiting to hear if the business court's pronouncement is the law, there's all the reason in the world for this court to cover this issue that is potentially dispositive, goes to the heart of the case. Even with the other rulings the court made, this legal issue does apply to several of the plaintiffs. And by all means, the question of net worth and sophisticated investor will come up at trial. So it is not in any way an advisory opinion. It is something that this court can declare that will make a big difference in this case and beyond. In conclusion, what Window World is asking for here is for this court to declare what the law is on the key legal issues that are brought before this court. Not to go document by document, not to engage in the work that trial courts do so well, but to
Counsel, I
pronounce
believe your
issues.
time's expired.
Thank you, Your Honor.
Thank you. Thank you to everyone. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess until the next calling of the calendar. God save the state and this honorable court.